Chase. Good morning, sir. And I see Mr. Stone. Excellent. All right. So, Mr. Chase, you're here on behalf of the appellant. When you're ready to proceed, please proceed and let me know how much time do you wish for rebuttal, sir.
Yes, I would like to reserve 5 minutes.
Very good, sir. You may proceed.
Okay. I'm here on behalf of Louis LaRocca. Mr. LaRocca is currently serving a sentence of 20 years imprisonment for armed burglary and other offenses. Mr. LaRocca pled guilty to the charges against him pursuant to a plea agreement, and the issue before this court is simply whether his plea was knowingly, intelligently, and voluntarily entered. Case law is clear that in order for a plea to be knowingly and voluntarily made, it must represent an intelligent choice among the alternative courses of action open to the defendant. Here, it's undisputed that trial counsel advised Mr. LaRocca his only options were to accept the state's plea offer or proceed to trial, and trial counsel failed to advise Mr. LaRocca he had an alternative option, which would have been entering an open no contest plea to the court. Accordingly, Mr. LaRocca's plea doesn't represent an intelligent choice among the alternative options available to him because he simply wasn't aware of all of the options that were available to him.
Would he have had to show or suggest that had he pled open, that the trial judge would have been more lenient in the sentence?
I don't believe so. The question is just whether he knowingly waived that right. I don't think from the case law that there's any requirement that he would have had to receive a more favorable result. The prejudice is inherent in an unknowing plea because he's essentially waived the right to make that knowing choice. The choice is his to make, and that's what's important. And really the inquiry is just whether a rational defendant would have, possibly gone the other way with this had they known of the choice. So the question is really just whether he knew of it, and if he didn't, the plea is involuntary, and that's really the end of the prejudice inquiry.
And if I may, Mr. Chase, so what is our review under the circumstances? Because as you know, this is a request to withdraw the plea after sentencing.
Right. So it's a manifest injustice standard, but that just relates back, according to the case law, to just a question of whether it's an involuntary plea. And since the circumstances of the plea weren't voluntary, it's very clear that he wasn't aware of all of the choices available to him. His plea couldn't possibly be considered to be voluntary, and that's really the end of the inquiry. Once you determine that it's not voluntary, that's it. According to the case law, that's a manifest injustice, and it has to be set back.
So how do you respond if you look at the plea colloquy? And I know you've indicated that the sole reason that you're proceeding is not the fact that he entered his plea at the time based on the information that he had, voluntarily and intelligent. You're taking the position because he was not advised of just this aspect that he could enter an open plea, that by virtue of that deficiency, that creates and manifests injustice, rendering his plea basically not knowingly or not voluntarily made. Is that your position?
That's correct, because he has three options available to him, and he's only aware of them. That's undisputed. And again, going back to the United States Supreme Court decisions that say that that for a plea to be knowingly and voluntarily made, it must be represent an intelligent choice. It's difficult, if not impossible, to say that it's an intelligent choice when you don't even know all of your options. So
it sounds though like you would have us adopt a complete new standard, almost an absolute standard, that lack of knowledge of an open plea would 100% allow a defendant to withdraw a plea at a later date.
Frankly, yes, I would. At this point, we have, if a defendant doesn't know he has a right to trial, that's 100% going to give him an opportunity.
Do you have any case law that, you're asking us to just forge ahead on a complete new standard? There's no case law that you would have us adopt for that standard? Are there other states or anyone else that follows that it's an absolute if you don't have that information, even though, you've got somebody facing a life in prison who accepted 20 years. And
I can't say that.
Go ahead.
I can't. I have a case that I have found 100% on point with this. won't pretend that I have. But I would point out that one of the cases that I've cited within the briefs here, I believe it's Brazil. They point out that Florida law recognized that a plea or no longer contender may be vacated when defendant has entered his plea as a result of mistaken advice by defense counsel as to the consequences of his plea. And that's what we have here. He's provided him with advice about what the consequences of his plea are. He's given him two options. You either plead to this and receive the 20 years, or you go to trial. What he failed to advise him as a consequence of accepting this plea is that he was also waiving the right to plead open to the court and have the court determine his sentence. So I would point out that there is an indication in the case law, maybe not specifically saying that he has to be notified of this, but in reality, that's what these cases are saying, because it is a direct consequence of his plea. And there is case law that definitively says that he has to be notified of direct consequences of his plea. And I would submit that this is a direct consequence that the case law would require he be advised of.
Mr. Chase, I think your argument is that means for those cases, every single change of plea that has been entered into by all the defendants in the past, that all those would have to be all set aside, because for the majority of them, they were never given the option that they could enter an open plea before the court. Is that
No.
suggesting?
No, I'm not. And the reason I say that is because the duty ultimately falls on, obviously the trial court has a responsibility to make sure that there's, pleas are being entered voluntarily. And I understand that part of the traditional plea inquiry doesn't encompass this. It doesn't advise the defendants of that. But it's counsel's responsibility to make sure that the client is aware of that. So you would like to believe in the normal course of things that your average defense attorney is giving the defendant the three options. He's saying you can accept this plea, we can plead open, or we can go to trial. Now, I will say that based on their plea colloquy, most defendants can get themselves to a hearing based on this argument because it's not going to be in the colloquy. But once they get to that point, most of the time, 99% of the time, they're not going to get any argument because the attorney get on the stand and say, well, no, we went over this. He knew this option. I advised him of this. End of inquiry. So we're not opening the floodgates here to relief, to throwing out all these pleas. It's going to be a very limited, probably a very rare circumstance where the defendant can show that he wasn't aware of it. The attorney didn't advise him of it.
And how do you respond to this, the fact that you made reference to the plea colloquy, and as you know, the Supreme Court has indicated the appropriate language for circuit judges to go through. The fact that that's not in it, doesn't that render your request, it being manifest injustice and the involuntariness of the plea, doesn't that undermine your argument?
No, because I don't think that they've ever indicated that that list is all inclusive. They're not saying that this is just the be all end all. At the end of the day, the question is still whether or not it's been known until they entered, and they also have, indicated through case law that a defendant also needs to be aware of all direct consequences of his plea. And so, no, I don't think the fact that it's not in the standard colloquy really makes one difference or another. There's no indication, as far as I know, that the court has ever said that this is an all-inclusive list. This are the only things that matter. So I don't believe that really changes things one way or the other. With respect to the plea acknowledgments, Mr. LaRocca's plea acknowledgments, I don't believe that any of those really impact this either. At the end of the day, the acknowledgments that he made were without the knowledge that he had other option, and he can't ultimately be the one that decides whether a plea is knowingly or voluntarily entered. It's a legal question for the court. So his kind of self-assessment, which is made from a point of view without all of the relevant facts, really doesn't change the inquiry here in terms of whether the plea was knowingly made. I know that there's definitely cases out there that say you can't go behind plea acknowledgments or plea statements, but if you look at those cases, they're almost always, in fact, always, I can tell, we're talking about some kind of a statement of fact, a yes or no, did you talk about this, yes or no, that you can't go behind that acknowledgement. But here, really, it's a legal question. It's not a statement of fact. It's a legal question based on fact. and he's not qualified to make that assessment. And I don't think that his kind of input on that really makes a difference one way or the other. At the end of the day, whether a plea is involuntarily entered is going to be based on the totality of the circumstances. So at most, you would factor in the fact that he said that it was, a knowing plea, and then weigh against that all of the evidence to the contrary, and decide if his knowing assessment changes those facts. It doesn't. Mr. was not knowingly made, and I would submit that because of that, like I indicated earlier, case law is clear that that's the end of the question. Once we demonstrate that if there's no voluntary entry of a plea, that in and of itself is a manifest injustice, and he's entitled to have the plea vacated. If you wanted to go down the other route, that the state has indicated that we have to go into this additional prejudice inquiry, which I don't believe we should be doing or that you should do. But nonetheless, if you were to take that approach, I still think that he's entitled to relief. It's very clear that the prejudice inquiry just focuses on what a rational individual or rational defendant would have done or may have done with proper advice. And I don't think that you can reasonably say that it would have been irrational for him to have entered a no contest plea open to the court had he known that was an option. So really, no matter how you want to look at the prejudice part of this, I think that all roads lead to him having his plea vacated.
But when you talk about what would be rational, I go back to my first question. Shouldn't there be some indication that the trial court would have given him a better deal than the state was willing to give him?
No, because the prejudice is in the involuntary plea itself and in the waiver of the hearing itself. It's no different than the analysis that in terms of not being aware of the fact that he's forfeiting a right to the trial. You don't have to show that you would have been successful at the trial. You just have to show that you were deprived of the option of going to trial, and that it would have been rational to take the option. So no, I don't think that there's any kind of showing required that you would have ultimately received a better result by doing so. But even if you wanted to look at that, it still would just be a reasonable probability of a different result. And I think here, a reasonable probability, if you look at the case law, it's not a more probable than not, it's not a, reasonable doubt, anything like that. The case law indicates it can be even less than a 50% chance, and it still would be considered a reasonable probability. And I think that a reasonable probability does exist that he would have received a different result or a better result had he pled open, had he known about this and pled open, because again, he's effectively a first-time offender. He scores out to only 11 years imprisonment. Under these circumstances, I think there's at least a showing of a reasonable probability that if he pleads open, that he's going to fare no worse anyway, and may in fact fare better. So even if you do want to look at that, I don't think it changes the result in Mr. LaRocca's case.
Either way, he would have been going before a judge for his sentencing. If he didn't accept the plea, either he was going to trial and before a judge, and maybe possibly facing some mandatory minimums or other things that might have applied, or he may have decided at a later date not to go forward with trial if at that point he had a discussion with his attorney. So isn't it fair to say that at least in some circumstances out there, that when a defense attorney makes a decision when they're talking that day with their client, this is your choice, we're proceeding to trial, or you take the state's offer? It sounds like you're saying it's an absolute. If they don't say, oh, or there's a chance right now, if instead you want to not go to trial and go ahead and admit everything, then you could plead to the judge now instead of waiting after trial. It sounds like you're saying if you don't explain all of that to them, it's an absolute.
Yeah, I agree. That is what I'm saying, because at the end of the day, an attorney has a responsibility to notify the defendant of all of the options available to him. And
that there should be no consideration of the fact that either way he's going to a judge for the sentencing under your scenario, that he's facing a judge before trial if he chose to do that, or after trial. So there is a fork in the road at that point. Either he's taking an offer that the state gives him, or he's going down the path towards trial with a judge ultimately making that decision.
But yeah, I don't think that it makes one bit of a difference, because the choice is his to make. And I understand what you're saying is that he's still going to get there. He's still going to have a judge, ultimately make a sentencing decision if he goes down the trial route, but he has the option of not going through a trial, which in itself can keep things away from a judge as consideration, because there's always going to be things that come out of trial that maybe wouldn't have otherwise come out. If you had just pled open, there's all kinds of case law that recognizes that you can make a rational decision just to be open to avoid things coming out, at trial that may be worse off and impact your sentence. And so I don't think the fact that, he ultimately can get before a sentencing judge impacts that at all, because again, he needs to be aware of the fact that he can forego that trial. He can kind of limit the information that's going to be before the sentencing court by pleading open to the court, and that's his decision, his prerogative, and to make that choice. And without proper knowledge that that's an option, he can't make an intelligent decision between those three options. So I think at the end of the day, no matter how you analyze this, without knowledge of those three options, it's effectively a per se ineffective. Well, not ineffective. Well, you could make the argument it's ineffective, but that's not what we're here for. It's involuntary.
Would you like to save the remainder of your time for rebuttal, Mr. Chase?
Yes, I would.
Very good. Thank you, sir. And if I'm going to ask you to mute your microphone. Excellent. All right, Mr. Stone, you may proceed, sir.
Thank you, Your Honor. May it please the court, I'm Will Stone on behalf of the state of Florida. Appellant LaRocca was facing 3 separate felony cases in Pinellas County with 6 charged crimes between them, including 4 burglaries, one of which was an armed burglary of 4 separate dwellings on different dates. He was also facing a count of first-degree grand theft, carrying a maximum sentence of 30 years. He entered a negotiated plea that consolidated these cases for sentencing purposes, and the sentences were run concurrently with the highest sentence being 20 years. When he entered the plea, trial was scheduled for the next day. So this was not like it was 6 months out from trial. He was kind of right down to the wire. He entered the plea, and appellant stated that he was satisfied with Mr. Cobb's representation. He had read and understood the plea form, understood the maximum sentences he faced, and entered the plea knowingly and voluntarily. Now appellant comes to this court, as in the circuit court, seeking to withdraw his plea on the grounds that it was involuntary and unknowing. But his objection is not to the plea per se, because he testified that it was not his wish to go to trial. It was always his intent to plea, but he wanted his sentencing carried out in a different manner. So I would argue that there's no manifest injustice as to the actual plea and convictions. At the evidentiary hearing last year, he comes up with this argument about just shy of 4 years post-sentencing that he wanted to make an open plea, no strings attached, and put himself at the mercy of the court for sentencing. The trial court was within its discretion to find that this claim was not credible. As to counsel's actions, appellant's own testimony was that his attorney came to him and said the negotiated plea for 20 years was the best option. This advice was reasonable under the circumstances, notwithstanding appellant's subjective hope for a lighter sentence through an open plea. The court could also have concluded that appellant knew, as I think most defendants do, that you can go into court at any time and change your plea to guilty or no contest and proceed to a sentencing, hoping for the best, and that he didn't need counsel to inform him of that. But even assuming a court believes that appellant did not know about open pleas, this is not a case involving misadvice in which appellant asked his counsel if he could enter a plea and have sentencing subject to the court, and counsel said, no, that's not an option available to you. In effect, what appellant is arguing is imposing a duty on counsel to ascertain that appellant does not know about open pleas and intuit that that's something his client might want to do and inform him of it. I haven't come across anything in the case law to suggest that counsel is required to do that. Finally, what's his prejudice? There was no evidence presented that appellant would have received a lower sentence had he made an open plea, apart from this subjective hope he had. We know that the state wanted more than 15 years because it rejected an offer proposed by defendant for 15 years. And his sentence could have gone up to life plus a great many years if they were run consecutive, as they could have been, given that these were different criminal episodes. An appellant is not even saying that he wouldn't have pled guilty or no contest, that he wanted to exercise his right to trial. He's saying 4 years after he was sentenced that he wanted a slightly different sentencing procedure. For these reasons, appellant has not established a compelling reason to withdraw his plea, and the state would ask this court to affirm. Thank you.
Thank you, Mr. Stone. I'm going to ask you to please mute. Oh, excellent. All right, Mr. Chase, you have your rebuttal time, sir.
Yeah, just a couple of things. Indicated there was no misadvice here. There was both a failure to advise and misadvice. The misadvice comes from the fact that he doesn't ever inform him that this is going to be a waiver. A direct consequence of his plea is going to be waiving the opportunity to open plea and have a court determine his sentence based off of that open plea. I would also like to touch on, or let me look at my notes here real quick. I'm sorry. The inherent prejudice in this is that he waived his right to have the judge move or consider his sentence at an independent sentencing hearing where the judge exercised the independent judgment without going to trial, as I said before. And it's the waiver of that option without knowledge of it that is the prejudice here. It's why the involuntary plea is inherently prejudicial, because he's effectively waiving his right to a hearing without knowing that the option even exists to have that hearing. And so
let me just ask you, I mean, going back to the very beginning of every criminal case, the way our system is laid out, they get an arraignment at first where they get to know about their information. And in some situations, the state may make an offer and others they don't. At that point, they're either pleading not guilty or pleading guilty, which is open to the court. So built into our system is there not this understanding that the judge is before you, and if you want to admit your guilt, that's part of the system. But yet you seem to be saying there has to be an express statement every time at every step of the trial before somebody accepts a plea. And I once again go back and ask you, show me where that has been the standard anywhere else and why we should adopt that as the standard.
Well, because he has to be shown, again, the basic standard is whether a plea represents a voluntary and intelligent choice among the alternative courses of action open to the defendant. And again, without knowledge that is a choice, it can't be an intelligent decision to forgo that option. And with respect to what you're getting at the arraignment stage, yes, I understand that they tell him you can either plead guilty or not guilty at that point. But what they don't tell them is what the consequences of doing either one of those actions are. They don't tell them, if you do plead guilty at this point, we're going to have a open plea or an open sentencing hearing where I'll just consider your sentence and this is what you're looking at and so on.
Well, I can't tell you for his because I haven't seen
Right.
what happened at the arraignment, but in most arraignments, the judge gets up ahead of time and gives a complete colloquy about the system so that there's some information available to them there. So I guess what I'm arguing, well, trying to find out is why there should be a standard, that an absolute standard that you're arguing for, that would give every criminal defendant, and I understand you're saying, oh no, it's not going to open up everybody who's out there, but going forward, if somebody after the fact, if it's not clear and they want to change their mind, say, I wasn't aware that I had this option for the judge to give that, even though in a situation like this where, I mean, I know when I was a trial judge, I would make sure they knew, okay, if you do this, you're facing life. And it's easy to forget now, and sitting on a panel, not understand that this man had a stark choice. And I understand you say he should have had a third choice, but that choice still involved a judge deciding that it was going to be less than 20 years, as Judge LaRose was asking, or up to life, or anywhere in between. So once again, an absolute standard.
Well, in the case of him going to trial, he's not, you know.
Can I interrupt you, Mr. Go ahead and answer Judge Tardo's question, but I want to let you know that this will be the end of your rebuttal time. Okay, thank you.
In the context, you know, oftentimes we hear about, you know, how you get credit for accepting responsibility, and that's going to be factored into your sentence. If you go to trial as a means by which to have that sentencing hearing and to have the court, you know, fashion an independent sentence upon you, you're no longer going to get that benefit of acceptance of responsibility. And so that's what the difference is in terms of him being available and having knowledge of these three options, because it puts him in a better position if he has an open no contest plea, because he's hopefully going to get the benefit of that kind of mitigating circumstance that, yes, I'm accepting responsibility. I'm not going to hold the state to their burden. And so that's the difference. That's why his ultimately a sentencing hearing at the end of the trial isn't kind of a band-aid for the fact that he wasn't aware of the fact that he had this option to begin with. Thank you.
Very good. Thank you, Mr. Chase. And thank you, Mr. Stone. So at this time, I'm going to ask you all to please exit so we could call our next case. Very good.